Good morning, ladies and gentlemen of the jury. You have patiently listened to the evidence in this case, and you've made personal sacrifices in your own lives in fulfillment of this important civic function. I know all the parties connected to this matter thank you for the careful attention that you've brought to your role here in this matter. We acknowledge it has been difficult on you at times. We are now at the part of the proceedings that are called the closing arguments, and this is where the attorneys will summarize our respective cases for you. Following our remarks, Judge Murphy will provide you with her instructions and the rules of law. But please keep in mind that we all have separate functions here. You are the judges of the facts. Only you decide what the facts of this case are. Attorney Gavin and I, we're advocates for our respective positions. Judge Murphy is in control of the proceedings, and she will provide you with the law that is pertinent to this case. She will instruct you to apply the facts as you determine them to be, to the laws as she gives it to you. Judge Murphy will define for you what is evidence in a case and what you may consider. And amongst the things that she will tell you is you can consider the exhibits that have been introduced to you by the parties and the testimony of the witnesses that took the stand during the case. But I ask you to recall, each one of you during your voir dire process, during the jury selection process, I asked each one of you, just because someone swears an oath to tell the truth, does that automatically mean to you that you will always get the truth? To that end, Judge Murphy is going to instruct you, caution you, and advise you that in deciding what facts to consider from the testimony of any witness, you may believe some of what that witness says, all of what they say, or nothing that they say, based upon the following criteria. How well was the witness able to recall the details and testify to them? What was the witness's manner while they were testifying to you? Did the witness have an interest in the outcome of the case or any bias, one side or another? How reasonable was the witness's testimony in light of all the other evidence in the case? And was that person's testimony contradicted by what that person said or did at another time, or by any other witness, or by any other evidence in the case? Judge Murphy will instruct you that if you think a witness has deliberately testified falsely in some respect, you should carefully consider whether you should rely on anything that witness said. So in other words, evidence is not just anything that is spoken from the witness stand. It must be credible. Judge Murphy will also tell you what is not evidence in a case such as this. First and foremost, she is going to tell you that these arguments, right now, the arguments of the lawyers, this is not evidence. As I mentioned earlier, the lawyers are advocates for our respective positions, and therefore we are inherently biased. Judge Murphy will instruct you that these arguments, or that the questions that are asked by the lawyers during the course of the case, that they're just argument. These arguments should point you to credible evidence in the case that supports the argument. Because argument that is not supported by credible evidence is just that. It is argument that is unsupported by the evidence. Because if it's not credible, then it's not evidence. Judge Murphy is going to tell you that you may not go outside the evidence, not to resort to guesswork or conjecture or speculation. She will tell you that while you may entertain an inference that a lawyer asks you to make, that inference must be drawn from credible evidence, and it must be reasonable and logical. It has to be reasonable and logical inference that relates to credible evidence. Because if not, then it's simply an inference unsupported by evidence. Now, in a few moments, the defendant's lawyer is going to come up here and he's going to tell you a number of things. He's going to tell you that the state has failed to prove its case to you because of two diametrically opposed reasons. He's going to tell you that the defendant didn't do this. Mr. Morales testified that home invaders killed Christine Holloway, left the only eyewitness to a brutal killing alive for some inexplicable reason, and then kidnapped Vanessa Morales. He is then going to suggest to you that if you do not believe the sworn testimony of his client, where his client raised his right hand and swore an oath to you, where he looked you right in the eye and flat out told you he was not responsible for this crime, then clearly he was on PCP, that this was a PCP-induced delusion, and that 5.5 years later, he still believes that there were home invaders that were responsible for this brutal crime. He is going to say to you, who calls 911 before killing somebody? He is going to point you to the 911 call and suggest to you that the tape supports the inference that his client was high on PCP. He is going to suggest to you that the brutality of the crime itself is evidence of aggressive behavior caused by acute PCP intoxication. He is going to suggest to you that there is no motive to otherwise cause such an attack. But remember, this is arguments of the defendant's lawyer. This is not evidence. Once Attorney Gavin lays out these inconsistent and diametrically opposed theories, I will come back and explain to you why the credible evidence in the case does not support the inferences that he is asking you to make, and why the only conclusion that you can possibly make from the credible evidence is that on December the 1st of 2019, sometime after 2 a.m. and before 6 a.m., Jose Morales intentionally caused the death of Christine Holloway by striking her in the head not less than 8 times with an instrument that caused blunt force trauma, thereby causing her death, and thereafter spending the next 36 plus hours systematically cleaning the crime scene in an attempt to erase all evidence and thereby existence of Christine Holloway until interrupted by the police beyond all reasonable doubt. I look forward to speaking with you again after Attorney Gavin's comments. Thank you, Your Honor.
Thank you, Attorney Gavin.
Thank you, Your Honor. Good morning, everyone. I guess I shouldn't have spent Easter Day at my kitchen table figuring out what I was going to say to you today, because the state has it all framed out for you already. But that's really not the case. I want to thank you for your service. I want to thank you for your attention. And I know that your lives have been interrupted, your family lives, your work lives, your everyday affairs, to be with us today. And I appreciate your attention and dedication. I think we're about 2 weeks ahead of schedule, so hopefully that gives you a little buffer. In the most difficult of circumstances, I tried my best to fairly and accurately provide you with all of the information for your consideration regarding the events of December 2019, the good and the bad. The state offered almost 200 exhibits in this case, and as you know, I didn't object to any of them. Let the jury see all of the exhibits in the case. I wanted you to have all the evidence to make an informed decision here. And as the state said, this is my only opportunity to speak to you, and I welcome it. As prosecutors, we get trained, and prosecutors in this case are trained to reserve their comments until the latter portion or the rebuttal portion of their closing argument. That's because the state has the burden of proving the case, so they get to go twice. And that's what's going to happen in this case. And why are they trained in that regard? Well, the first is so that they can get up and say everything that I argue to you should be discounted and not taken into consideration. And the second is how we handle our everyday affairs. The state likes to get the last word in. That's just how our system works, because they have the burden of proving their case, and we don't have the burden of proving everything. So, what do we know after months of jury selection, and 9 days of evidence. We know the state has not proven a murder case against Jose Morales. In February and March, when we selected the jury, I asked each and every one of you to bring your good common sense to court with you, and you promised me that you would. And now I'm going to ask you to use that good common sense and apply it in your deliberations. The benefit that you're going to have now that we didn't have during jury selection is we're going to have the opportunity for the jury to hear the applicable law of the state of Connecticut as given to you by Judge Murphy. And I'm going to ask you to listen to her instructions and respectfully to follow her instructions in regard to the evidence that was presented to you. Please always remember there are two principles of our judicial system that are the backbone of the system. The first is Jose Morales, as he sits here, is presumed to be innocent. Despite having all of the trial and all the evidence go in here, he's presumed to be innocent. And the second is that the state has the burden of proving these charges beyond a reasonable doubt, which they have not done, and we're going to discuss reasonable doubt in a second. Trust me, if you weren't reasonable people, you wouldn't be sitting in the jury box today. I'm confident that you all have good reason and you brought it with you and you applied it as you listened to the evidence. We have faith in you. Please remember that your doubts do not have to be unanimous. And what that means is your reasonable doubts in regard to what occurred back in December of 2019 can come from any different areas, and I make some suggestions to you. Jurors could say, I have a reasonable doubt about what actually happened on Sunday, December 1st, 2019. Totally appropriate and fair. Others could say, I have a reasonable doubt because the state has not proven its case at that high standard of proof beyond a reasonable doubt. Others could say, who calls 911 before committing a homicide? There's no evidence there was any problem between Christine Holloway and Jose Morales on that date. Others could say admitted PCP use causes me to believe that Jose Morales could not have formed the specific intent that is required to prove a murder case. These are just some of the examples, and there are many other ways and many other reasons. I'm going to ask you specifically to consider these facts. Chelsea, if you wouldn't mind. This is the 911 call. Thank you, Chelsea. Thank you. Use your good common sense. Who calls 911 before committing a homicide? No one. And don't forget, that's Christine Holloway's voice in the background on the call. Christine was there. I want you to please respectfully ask yourself, why did the state try to hide the issue of PCP in this case? Why? PCP use clearly happened. Morales testified in regard to going to Bridgeport with Rodriguez, getting the PCP, having 2 bags of PCP with him, and his continued ingestion over the weekend. Morales had ingested PCP on December 1st. You can hear it in his voice. He was barely able to speak. Remember the testimony of Officer Jacqueline Tresser, who was assigned, that was the police officer that was assigned as the dispatcher. That's whose voice you hear. What do you hear? Her testimony. She said, voice slurred. No screaming or yelling between Jose and Christine. No physical violence, no confrontation whatsoever. Ask yourself, why didn't you hear from Detective Stephen Adcox, the lead investigator in this case? It wasn't presented here for you.
Your Honor, I'm going to object with regard to this. This is not appropriate argument
All right.
with regard to.
Let's move on in the argument. We'll reserve the objection. Counsel.
Thank you. As you know, Morales was interviewed and his interviews were recorded December 3rd, December 12th, December 17th, December 23rd, January 9th, January 21st. As Morales' memory came back from the use of PCP, he told the police what happened. This is not some manufactured story from 5 years later. This was contemporaneous with his arrest and the investigation in this case. The police even sent his mother, Lydia De Jesus, into Cheshire Correction, as you recall, on December 9th, and it was recorded as he was talking to his mom. Morales' story is completely consistent from December of 2019 right up through and today. As soon as Morales' PCP clouded memory came back, he told the police what happened. What's the supporting evidence of that? The 911 call, where clearly he's impaired. Now, how about the surveillance video showing the home intruders leaving the area of Myrtle Avenue, which we played for you? That was Exhibit F, G, and H, where Morales indicated he went to the front door, he looked outside, he saw the vehicle coming down Myrtle Avenue, and the second assailant got in the car, and it's on video. You can't manufacture that. That's there. Did the state introduce that? No. Why wasn't it introduced? Because it didn't fit their theory that this was an open and shut case, which it isn't. Morales took the stand, didn't have to testify, and owned everything that he did. And by the way, after 5+ years and all of these investigators and all of these police officers and the FBI and the New Haven police and all the other agencies, you know what you don't have? The state never produced a murder weapon for you. Not once. You can take that into consideration as well. There's another reason why the state wanted to hide the PCP intoxication evidence from you. That's because of what Judge Murphy is going to instruct you regarding the law of the state of Connecticut. And from this instruction, the jury can't vary. In any prosecution for an offense, evidence of intoxication, so the first thing you have to say is, what is intoxication? A substantial disturbance of mental or physical capabilities resulting from the introduction of substances into the body. That's the PCP. It can apply to alcohol, it can apply to any number of drugs, but in this case it has to do with PCP. That evidence may be offered to negate an element of the crime charged. In a murder case, the state has to show there was specific intent to kill. It's not here. Specific intent to kill is, I hate Ed Gavin, I'm going to shoot Ed Gavin, I want to kill Ed Gavin. There is no evidence of specific intent brought to you by the state in this case. Absolutely none, which is required in order to successfully prove the charge of murder. Much to the state's discomfort, Judge Murphy's going to instruct you, if you find the defendant was intoxicated, you may take that fact into consideration in determining whether a defendant was in such a state of intoxication as to be incapable of forming the required specific intent, which is a necessary element of the crime. That's from the court. Listen to her instruction. I believe the judge is going to provide you with a written copy of her instruction. You'll find it right in there under the intoxication section. In regard to specific intent, There's an old trick that prosecutors use. And I don't know what Mr. Stein's going to do, but in the past, this is the way that prosecutors are taught. If there's no evidence of specific intent, which is not in this case, then what you do is you argue to the jury that the number of gunshots, or if it's a stabbing, or if it's an assault with a bat, show the jury the specific intent. That is not the case. It's a way to go ahead and hide the fact that you can't show the specific intent. The evidence doesn't support it. The state still has to show the defendant intended to achieve a specific result, and they just didn't do it in this case. The evidence in this case only shows a lack of intent. What do you know from the evidence? The day before Thanksgiving, Wednesday, everyone's over in New Haven at Morales' parents' house. They're doing Christmas decorations. They sleep over that night. What happens the next day? The next day is Thanksgiving. We just had Easter yesterday. It was Thanksgiving. It's a joyous time. What do? They go to Bridgeport. You know that from the CAST report showing the cell tower tracking, okay? They go to Bridgeport. They spend time with Christine's family. They come back to New Haven. They have dinner with the Morales family at that time. Relatives are over. It's a joyous occasion. No problems, none. What happens the following day, on Friday? They go to Barberino and buy a new car. It's a happy, fun, joyous occasion. 5 hours they're at Barberino. Saturday, Jose Morales, Christine are in Ansonia at 6.5 Myrtle Avenue. No problems, no issues, no screaming, no yelling, no fighting, nothing. No specific intent. And then you hear, which we just played, the 911 call. And you don't hear any fighting or arguing there. You know, what's so popular in these cases is the reliance on forensic evidence. My bride of 40 years watches these crime shows over and over, and she tells me it always comes down to forensic evidence. What's the forensic evidence that was offered to you for your consideration here? Number one, there's no evidence of Jose Morales' DNA under Christine Holloway's fingernails. If this was this brutal murder committed by Jose Morales that the state alleged, you would see that evidence. We had the benefit of the lab. We had the two examiners of the lab, eminently qualified people, super smart people. And you know what? The reality is that there was no evidence of Jose Morales, of his DNA, under Christine Holloway's fingernails. And you can go back and we put the forensic reports in for you to go ahead and take a look at that. That's the reality of life. You would expect to find that. Then you have to go back and you have to say, well, what is going on here from the evidence that was submitted by the state? Well, the first thing that I think you would do is, because you have all that data, we introduced everything without objection, is Christine Holloway's cell phone. You see that Christine Holloway's cell phone calls the Morales cell phone on the morning of September 1st. Dave Carney was the fellow from the FBI, the special agent from the FBI, did a great job on that CAST report, showing you day by day the transmissions and where the cell phones were binging off the towers. I thought he did a very, very good job. And you can even see from his analysis that on Sunday the 1st, you see Christine's cell phone binging off another tower in New Haven, different from Morales. And the real kicker here is, the real issue here is, what do you see in regard to Monday, December 2nd? You saw it in evidence here over and over. Christine's cell phone is binging off of the towers in Naugatuck when you know Morales is in New Haven. His cell phone has him down in New Haven, and the second to last page of the cast report has that big red umbrella all over Naugatuck. That's where Christine's cell phone was. How about the other forensic science evidence? Morales testified to every single piece of it. Going to the donation bins. He told you he did that. Going to the Shell gas station, which is on the video. He told you that was him. The camera picking him up from Maria's hair design. He acknowledged that was him in the car that was there. Going past the Ansonia Police Department building on Elm Street. That was him. He was there. He testified to that. The entire video montage that the state introduced, that I played for him when he took the stand, what did he tell you? That was me. Yep, that's me. 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 The fact that Morales readily admitted cleaning up does not mean that he committed the homicide. Apples and oranges, totally separate issues. In fact, I'm going to call on you to please, again, use your good common sense here. Does it make any sense to commit a homicide? Just think about this. Commit a homicide and then go ahead and put the crime scene evidence in a donation bin, by definition, where it's going to be found? Does that make any sense to you at all? No, it doesn't. Remember the testimony of Dr. Frazier. And by the way, did you hear the state call an expert to contest the testimony of Dr. Frazier? No. You know why? There was nothing to contest. What did Dr. Frazier tell you? Number one, PCP has been around since the 40s. Number two, PCP amnesia is real. It happens when you ingest PCP. Sometimes memory comes back. Sometimes it doesn't come back. PCP can last in the system for over a week. What did Morales do? What's the evidence show you what he did? As his memory is coming back, he's constantly in contact with the police to provide a voluntary statement to the police that's recorded. He's under no obligation to talk to the police, but he does. He goes in there. He talks to them on the 3rd. He talks to them on December 12th. He talks to them on December 17th. He talks to them on December 23rd. He talks to them on January 9th. He talks to them on January 21st. And what does he say? He says, this is coming back to me, and as it's coming back to me, he's providing the evidence to the police department. It's not like he made up some story all of a sudden. That's just not what happened, ladies and gentlemen of the jury. I appreciate the opportunity of having a chance to speak to you. Please, if it doesn't add up, and in this case, the one thing that's clear, it doesn't add up, then you have a basis for a reasonable doubt. And if you have a basis for a reasonable doubt, your obligation of a juror is to go ahead and render a verdict of not guilty. Please listen to Judge Murphy's instructions. It's not my instructions. It's the court's instructions in regard to the applicable law here. And it doesn't matter from juror to juror where your doubt comes. It doesn't matter if it's because of PCP use or because of inconsistent statements or the forensic evidence or the 911 call. All 9 days worth of evidence, you can consider any and all of it. Use only the evidence presented to you in this courtroom. Use your good common sense and render the fair, just, and reasonable verdict of not guilty to the offense of murder. I thank you for your time. Thank you.
Okay, just have a moment, Your Honor.
Certainly.
I'm ready to proceed, Your Honor. Thank you.
All right, very good. You may proceed.
And there, ladies and gentlemen, you have it. It's not normally my habit to chase the comments of what the defense asks in something like this, but I feel compelled to respond to some of them. The reference to Stephen Adcox, why the state didn't call. You know, I'm fascinated by any time I hear an argument like that because neither party owns witnesses. Any party has got the right to call any witness they want to put that witness in front of you. Did you hear the defendant call Stephen Adcox as a witness? Or for that matter, Hector Rodriguez or any of the other witnesses that could corroborate what Mr. Morales put in front of you. The videotape of the real killers, we've heard about the real killers from Mr. Morales in this particular case. I'll leave that to you to decide the value of that videotape. What the defendant said to Stephen Adcox at any point in time, there's no evidence in this case. Mr. Morales didn't talk about the details. So that's argument from Attorney Gavin, unsupported by any evidence, because you know nothing about what was supposedly said at any of these subsequent statements. The forensic evidence, right? When I hear arguments about forensic evidence like this, right? So first he asks you to assume that because Christine Holloway did not have the defendant's DNAs under her fingernails, that means something. Well, what does it mean? Does it mean that she never saw the first blow coming? She wasn't in a position to defend herself or scratch him to get his DNA under her fingernails? And think for a second if her DNA, or rather if his DNA was under her fingernails, what would the defense argument be then? Of course his DNA is there. They're in a relationship together. They're a couple. You would expect to find his DNA there. So that type of an argument is completely, I submit to you, without value in a case like this. But it's a distraction that he wants you to focus on. I submit to you, the judge will tell you that you are the judges of the facts, your memory of the facts. And if you have any doubts about the facts, you can ask the judge to replay any portion of any witness's testimony for you. Because without going through point by point, Attorney Gavin's just flat wrong on the cash report on many different items. And his timing or his memory of what that report shows, I'm not going to even go there. I'm just going to suggest if it's not readily apparent to you when you look at the report, you can have any witness charged back to you with regard to that. So let's just talk then about what we've heard here. You have Attorney Gavin's alternate theories here. The defendant takes the stand. He swears this oath to tell the truth. He's led on a direct examination by his attorney. And I'm sorry, I'm just timing myself here. My time clock's not working. He stands, he takes an oath to tell the truth. He's led on a direct examination by his lawyer, and he tells a story that seems to be unsupported by any credible evidence. Just so his lawyer can stand before you during the closing argument and ask you to draw an inference that his client was suffering from a PCP-induced delusion at the time of the murder, and now 5.5 years later, he makes the claim that he is still suffering from that same delusion. But think about it for a second. He is asking you to believe his client, but just in case you don't, here's the backup theory. Does any of that make sense to you, let alone in a case such as this, would you be able to draw these reasonable inferences from the evidence? Before I get into why the credible evidence in this case should convince you beyond all reasonable doubt, let me touch on some of the further aspects of the law that Judge Murphy is going to instruct you on. It goes without saying that if my comments or Attorney Gavin's comments ever conflict with or misstate the law in any way, you should always follow Judge Murphy's instructions on the law. Attorney Gavin argued that his theories should raise to a reasonable doubt in your mind, but the court is going to define reasonable doubt for you. She was going to tell you that a doubt must be a real doubt. It must be based in the evidence or the lack of evidence, but it is not a doubt that is based in speculation or surmise or guesswork or conjecture, or a doubt simply because Attorney Gavin wants to raise a reasonable doubt, because that is not reasonable doubt. But isn't that exactly what Attorney Gavin is asking you to do here? The court will tell you that proof beyond a reasonable doubt does not mean proof beyond all doubt. The law does not require absolute certainty on the part of the jury before reaching a verdict of guilty. Now, I want to talk to you about the offenses that Mr. Morales is charged with, starting first with the second count of that document, the charging information, which you will have with you during your deliberations. That's tampering with physical evidence. I'm not going to spend much time going over the testimony with you. Rather, I would suggest to each one of you that all of the elements that Judge Murphy will instruct you on with regard to this offense can be found directly in the defendant's testimony, where he told you how he cleaned the crime scene and disposed of physical evidence in the education bins and destroyed evidence in the garbage disposal. So let's get right to the crime of murder. Judge Murphy is going to tell you that in order to find the defendant guilty, that Jose Morales intended to cause the death of Christine Holloway, and acting with that intent, he caused her death. So let's talk about intent. Judge Murphy is going to tell you there is no particular length of time necessary for the defendant to have formulated this intent. In other words, intent can be created in an instant, such as when a person engages in a sudden rage. The intention does not have to be long-standing. It doesn't have to be festering spite or ill will over a long period of time. It is an intention that can be created in a moment's time. The judge will also tell you with regard to intent that it may be and is usually inferred from the circumstances of the crime. Attorney Gavin would have you believe that we go to school, prosecutor school, to learn the tricks. This is based in the law. Judge Murphy is going to give you this out of her own mouth as to how you may look at the circumstances of the crime, because no witness can come into court and testify that they looked into the defendant's mind and therein determine what the person's intent was. You can't get direct evidence through any other way. The court will tell you that by using circumstantial evidence, you may examine such things as the number of wounds, the location of the wounds on Christine Holloway's body, the type of instrument that was used to create those wounds. It's circumstantial evidence. It's logical. If I decide to hit somebody in the head multiple times versus smack them in the toe with the same instrument, does that not manifest the person's intent when you strike somebody in the head versus in the toe as to what your intent was when you brought each one of those blows down time after time? To infer intent is part of your responsibility with regarding to determine the facts of this case. And you are permitted to infer the intent by the methods that Judge Murphy will tell you. In this case, the state contends the defendant struck Christine Holloway in the head with not less than 8 times with a blunt instrument that created 1-inch round circles with a reasonable inference which a reasonable inference from that evidence conclude was a hammer. I would suggest to you that the evidence supports the inference that a person who strikes another person in the head with a hammer not less than 8 times intended to cause catastrophic injury and death. There is no other rational conclusion. This clearly manifests an intent to kill and not an intent to wound. The second element of the crime of murder is, did cause the death. And you heard the testimony of the medical examiners that Christine Holloway died of blunt force trauma as a result of these injuries. Attorney Gavin did not argue to you about the lesser included offenses, but ultimately, the judge is going to instruct you in their request that you consider these lesser included offenses based solely on the self-serving statements of Mr. Morales that PCP was even involved in this case. You heard from no other witness, no other evidence that PCP is even involved in this case except from Mr. Morales. Attorney Gavin tries to bolster his alternative theory with the 911 call, Dr. Frazier, and the CAS report, trying to get you to accept part of the defendant's story that fits Attorney Gavin's alternate theory, even though his client flat out disagrees with that alternate theory. Members of the jury, the credible evidence in this case should overwhelmingly convince you the defendant is guilty of murder. If you find that murder is proven, then the judge's instructions that will follow will tell you to disregard her instructions to you on the lesser included offenses. However, if all 12 of you unanimously agree that the defendant is not guilty of murder, then and only then can you consider any of the lesser included offenses that Judge Murphy is going to provide to you. You may not go to the lesser included offenses unless each and every one of you believe the defendant is not guilty of murder. You have to reach that one first. You cannot consider anything less unless you all unanimously agree that he is not guilty of murder. The defendant's lawyer argued to you that the basis for the reduction from murder to manslaughter is based upon the defendant's self-serving claim that he was intoxicated on PCP. Attorney Gavin argued to you that Jose Morales could not formulate the intent to commit murder due to that intoxication. Pay heed to the portion of Judge Murphy's instructions that if you deem the defendant to be intoxicated, the intoxication must be a substantial disturbance of mental and physical capabilities that effectively create an inability to formulate the intent necessary to commit murder. You may believe that the defendant, although intoxicated, was still capable of forming the specific intent. In that case, the defendant's responsibility is the same as if he were not intoxicated. It must be a substantial disturbance of physical and mental capabilities. So let's talk about what the credible evidence in this case shows you. The defendant would have you believe that everything in his world was bright and rosy. He talked about the wonderful holiday season he and his family were having at Thanksgiving time in 2019. But the reality for Christine Holloway was anything but that. Witnesses such as Rosie Clark and even Mr. Morales told you about Christine Holloway, hardworking, church-going, dedicated, single mother. Mr. Morales told you he was unemployed, stressed, living with his elderly parents in their basement, together with his two other children, who his parents were also supporting. He acknowledged that he was a part-time parent and part-time partner to Christine and Vanessa. He denied being a controlling and jealous, abusive man. However, his text messages tell a different story. Please take the time to carefully go through them, because therein lies the snapshot into Mr. Morales' life and motives that could cause him to fly into a rage and kill Christine Holloway. Clearly, he controlled and scrutinized her. Where was she? How did she spend her money? She professed her love for him and told him about the beautiful future she envisioned for their blended family, while he demands proof that she actually canceled her gym membership. He then has the gall to tell you on cross-examination, and then attempt to spin it that on the Friday morning following Thanksgiving, he went to the gym to inquire about his gym membership because he needed to get back in shape. He admitted to calling her a pig. He admitted that he would swear at her awful, nasty words. He admitted he didn't trust her. He admitted that he believed she was seeing other people. And no matter how much she reassured him, or professed her love for him, or sent videos of their child to him, or assured him that God would see them through these challenging times, she was never good enough. He toyed with her emotions, telling her, "This stupid relationship is done." That's only days before Thanksgiving. This man would tell you stories of the weekend of Christine's death. Sure, he had 5.5 long years to think about it, to review all the police reports and all the evidence in this case, to draw his maps and diagrams of 6.5 Myrtle Ave. Interestingly enough, leaving Vanessa's crib out of the diagram for 6.5 Myrtle Ave. His direct, did it seem scripted? Did it seem rehearsed? Did you notice on direct how Mr. Morales accounted for his movements of this PCP-fueled weekend right down to the exact minute? Did you notice his demeanor? Did you find him to be flat, cold, matter of fact? Did he show any signs of emotion during the crime scene or autopsy photos? And this is where Judge Murphy's instructions on credibility come in. The court will tell you you may consider his demeanor on the stand while he is testifying and the manner in which he is testifying. I'm not going to take you through all the details that Jose Morales gave you regarding his claims that other people killed Christine Holloway and kidnapped Vanessa Morales. I will simply reiterate the court's instructions that if you think a witness has deliberately testified falsely in some respect, you should carefully consider whether you rely anything that that witness has to say to you. So let's be clear. The only reason that PCP is even in this case is because Jose Morales took the stand and self-servingly told you he smoked PCP. Was that a setup for this alternative theory provided by Attorney Gavin? There's no other witness, no other exhibit, no other evidence that corroborates, confirms, or supports the defendant's assertion that he was using PCP that weekend. Sure, Attorney Gavin points to you the cast report in an attempt to bolster that theory. But all that report tells you is that the defendant's cell phone was tracked to the Bridgeport area. It doesn't tell you who he was with. It doesn't tell you what he did. Attorney Gavin points to the cell phone records and identifies Hector Morales. There's no evidence in this case that indicates where the defendant went, who he went with, or for what purpose other than Mr. Morales' self-serving statements. You would have to believe him to make inferences from the cast report or the cell phone records as to why he went to Bridgeport and for what purpose. And can you believe him? Attorney Gavin would have you believe that the 911 call is evidence of his client's PCP intoxication to once again bolster his alternate theory. I submit to you that all you can infer from the 911 tape is that Mr. Morales is slurring. In order for you to infer that the slurring is from PCP, it would require you to find Mr. Morales credible from this self-serving testimony. And again, can you believe anything that he says? Judge Murphy's credibility instructions will advise you further that you may consider from any witness who comes before you to testify whether that witness has an interest in the outcome of this case as a factor for you to determine his credibility. I submit to you, who has the greatest interest in the outcome of this case? Once again, the only evidence of PCP in this case comes from the lips of Jose Morales. Jose Morales spent nearly 2 weeks following this crime denying he was even with Christine Holloway that weekend. He denied it to the Ansonia Police, the Connecticut State Police, the FBI, his own family. You saw it on the tape. before finally introducing PCP into the conversation. Then the defense offers you Dr. Eric Frazier, a clinical psychologist, not a medical doctor, not a toxicologist. This is their expert on PCP. The court will instruct you that a person may testify as an expert before you if they have special knowledge or skill, experience, training, or education on the subject to which their testimony relates. I am not going to spend a lot of time on what Dr. Frazier said about his experience in the area of PCP. My cross of Dr. Frazier, together with his CV, which I put into evidence for you, I believe is all you need to know about Dr. Frazier's experience with PCP. Judge Murphy will instruct you that an expert's testimony is entitled to such weight as you find the expert's qualification in their field is entitled to receive. No such testimony is binding on you, and you may disregard it in whole or in part. It is not controlling upon your judgment. Dr. Frazier admitted he read several articles nearly a half-century old, combined it with his non-medical education and his 1 year of postgraduate clinical work from 20 years ago. And he told you all the horrible things that acute PCP intoxication does to a person for the tidy little sum of $10,000. I think he said that in his entire career, he has only seen one acute PCP intoxicated patient during his clinical time 20 years earlier. When instructing you on an expert's testimony, Judge Murphy will also remind you about the general instructions on witness credibility, because that also applies to experts. And one of those instructions enables you to consider a witness's bias and interest in your verdict. Dr. Frazier, does Dr. Frazier have a business interest in your verdict or a bias to one side or the other? That is for you to decide. Nevertheless, Dr. Frazier told you how acute PCP intoxication causes impaired cognitive ability. And Mr. Morales hopped right on during his subsequent testimony, telling you how everything goes dark, can't see, everything is blurred, can't stand or maintain balance, can't yell, can't scream as someone is killing your child's mother and carrying your child away. He told you how he becomes cognitively stuck. And that seems to fall right in line with what Dr. Frazier professes he read in those nearly half-century-old articles. However, a cognitive deficit-causing drug like PCP does not line up very well with the rest of the evidence in this case. Dr. Frazier told you the average half-life of PCP is 8 hours and even longer in higher doses. He told you that half-life is the point in time where the body has metabolized half the drug's potency. On cross-examination, I asked him to correlate cognitive function to executive function. I asked, you will recall, he agreed with me that executive function of the brain are those sets of cognitive process that help us self-regulate, plan, prioritize, and sustain efforts towards a goal. He then further agreed that key components of executive function would include working memory, that is, holding information temporarily in your mind so that you may work with it, set shifting and cognitive flexibility, which is the mind's ability of adapting to changing demands and the ability to switch between tasks. I then asked him if signs of executive dysfunction would include difficulty with planning, organizing, and prioritizing tasks, challenges with time management and staying on track, trouble with task completion and following multi-step instructions, problems with focusing, concentration, and paying attention, struggles with motivation and initiating tasks, inflexible thinking and difficulty adapting to change. And Dr. Frazier agreed with me that all of these things may be signs of executive dysfunction. And ladies and gentlemen of the jury, this is where the whole PCP story falls completely apart. Think about what this man did after this horrific act. We know that Christine Holloway is last alive in the early morning hours of Sunday, December 1st, 2019, when she is last heard on the 911 call. The defendant wants you to believe that someone else killed her. His lawyer wants you to believe that if you don't believe him, then it must be the PCP that they paid Dr. Frazier the tidy sum of $10,000 to explain to you. But no one took into account his post-homicidal behavior. We know that by 6 a.m., the defendant leaves 6.5 Myrtle Avenue in a car full of bloody stuff that he placed in garbage bags and staged on the deck. Think about that for a second. He carefully goes through all the stuff in the house, separates out the bloody stuff, carefully bags it, stages it on the porch, doesn't get blood on himself in the process, or cleans himself up after going through those steps, before he finishes the tasks in the house before 6 a.m., when the cameras catch him making his run to the education bins. How is he cognitively doing all of this a few short moments after smoking PCP, a drug with an average half-life of 8 hours, a drug that causes cognitive impairment? You know, the cognitive processes that help us plan, prioritize, and sustain efforts towards a goal. Does this behavior sound like a person that is cognitively struggling with planning, prioritizing in a sustained effort towards reaching a goal? I would suggest to you that his behavior seems very goal-oriented. And let's not leave it there. He climbs into an automobile at 6 a.m. within 4 hours of the last point in time we know Christine Holloway is alive, and he goes on the first of many goal-driven trips that weekend. Don't forget the goal-driven trip to New Haven at 4:30 in the morning on Monday morning in Christine Holloway's car, because his car is running low on gas. As the cast report shows, both phones leave 6.5. They're traveling together to New Haven. Both phones then go dark in New Haven until his suddenly comes back on 2 hours later. He's back in New Haven. Her phone comes back on at some point in time, and it's up in the Naugatuck Forest in close proximity to his nephew's house. Was he getting rid of the phone during that trip to New Haven? Did he explain any other purpose of why he would be going to New Haven at 4:30 in the morning? Does that sound like goal-driven behavior? And then the kidducation bins. On his trip, he navigates the roads out of Myrtle Avenue, out to Elm Street, drives right past the police station, mind you, and doesn't stop. He drives down to a 4-way major intersection at the area of Elm, Derby Ave, and Division Street. He successfully navigates that busy intersection. He drives all the way down to St. Michael's Church using cognitive, goal-driven behavior together with working knowledge to reach the bins that he knows are present at that location. Think about that for a second. Think about what it takes to drive a car. Think about all the cognitive functions that it takes to successfully drive a car and why law enforcement officers look to detect cognitively impaired drivers. Driving requires focus, sustained attention, goal destination, adapting to speed, other cars, pedestrians, traffic lights, stop signs. All of this requires cognitive function. And Mr. Morales and his attorney would like you to believe that he is cognitively impaired during this time, but his actions and abilities paint a very different picture. I think the most damning evidence of Mr. Morales' cognitive abilities is at the Shell gas station. 4 hours, after Christine Holloway is last heard alive. Watch that tape. Watch how he drives into the gas station, removes the keys from the ignition, climbs out of the car, accelerates his pace towards the door when he cognitively processes the nice man holding the door. He starts skipping forward, accelerates his pace because the door is being held for him. He approaches the register. He effortlessly communicates the brand of cigarettes that he wants. He reaches into his pocket. He locates a debit card. He looks at the card and orientates the magnetic strip. You'll see him. He finds where the magnetic strip is, and he effortlessly swipes it through the card reader. He quickly repositions the card to insert the chip side of the card into the slot when he realizes the magnetic strip isn't working. He follows a series of prompts to navigate through debit and credit choices. He effortlessly enters a PIN number, first once, then a second time. Not fumbling, each is a deliberate keystroke. He would like you to believe that he entered the wrong number. Isn't it equally probable that the card is inactive due to the problems that he's having with his bank? You heard about that on cross-examination. Or even that it's not even his card, perhaps Christine Holloway's card. But nevertheless, undeterred, he reaches into his pocket. He locates and counts out his cash. Doesn't that require cognitive process to do math like that? He has the cognitive ability to realize he doesn't have enough money, and he leaves, and he goes back to the car. He unlocks the car while the fob is still in his pocket. That's tactile. He's feeling. He can locate the buttons on the key fob. He never takes it out. He's not sitting there and pushing the buttons, cognitively sensing the fob and unlocking the car. He gets into the car, keys back in the ignition, not fumbling, not trying to missing it, right into the ignition. And even better then, puts on his seatbelt. Right on, no issues there. Turns his headlights on, yields to a pickup truck that is leaving the gas pumps and pulling up on his left. And then something truly amazing happens. The pickup truck goes out the gas station entrance from Division Street. Mr. Morales realizes that, and instead of following the pickup truck out the wrong way, he navigates. You see him correct his vehicle. He navigates to the right of the little traffic island that has the light pole on it. He navigates to where the station exit is because there is a painted arrow drawn on the ground that shows you where the exit is. And at that point, he yields, not to one car, but to two. And you can see that from the reverse camera shot from the hair salon, where you see the two cars go by him as he is waiting to make a left-hand turn. And off he goes. 4 hours after the last time Christine Holloway is heard alive, and well short of the 8-hour average half-life of PCP. So if it is not PCP, then what is it? The Ansonia police and the state police went through the entire house multiple times, even taking the sink apart, where they found pieces of Christine Holloway's skull that the defendant had the cognitive ability to grind up during his extensive cleaning efforts. No evidence was collected of any drug usage at 6.5 Myrtle Ave, let alone PCP. There is evidence of an intoxicant, however, and that is beer. Christine Holloway had no drugs or alcohol in her blood tox report. What other evidence exists in this case of alcohol usage? Oh yes, Mr. Morales' statement to you that the PCP hit him like a gallon of vodka. His words, not mine. Sounds like he may have some experience in the area, coupled with his acknowledgement that he had empty bottles of Dubra vodka stashed in the back of his bathroom closet. And how about the text messages? When he tells Christine Holloway early Thanksgiving morning that he went back out after she went to sleep with their sick child, only to tell her at 3:30 in the morning that he went back out and he thinks his mom got him. At 4 a.m. on Thanksgiving morning, Christine Holloway tells him that he's stupid and he needs to stop. He wants you to believe he is a happy family man. These text messages paint a much darker picture. So what happened on December 1st, 2019 at 2 a.m.? Dr. Frazier agreed with me that intoxicants in general, which certainly would include alcohol by their very nature, reduce inhibition, impair judgment, increase confidence, impact mood sometimes wildly, euphoric 1 minute, irritable the next, can produce arguments or negative interactions with others, and can enhance negative feelings and emotions. Mr. Morales' text messages show he has plenty of negative feelings towards Christine Holloway. The only credible evidence in this case of an intoxicant is alcohol. You will have to find Jose Morales credible and believable, since he is the only one who introduces PCP into this case at all. So did he dial 911? Did he wake Christine Holloway up when you hear her in the background quietly whispering, "Stop, who are you talking to? Hang up the phone"? Is she whispering because Vanessa Morales, who has been sick, look at the text messages, doctor's appointments, CVS. The text messages tell us that Vanessa has been sick and neither she nor Christine have been sleeping well. Mr. Morales reminded us as well that Christine was nursing at this point, and she was up during the night nursing. We certainly do not hear any home invasion happening. Do we even hear a TV on that suggests that Christine Holloway is up, as Mr. Morales would like you to believe she was? We hear 1 minute and 14 seconds of quiet whispering of the voices of Christine Holloway and Jose Morales. No home invaders, just a dead woman and a mystery surrounding the disappearance of a 14-month-old, both who were last seen in the presence of Jose Morales. So was Mr. Morales drinking? You don't need an expert to tell you about the effects and duration of alcohol. You may apply your own life experiences. Did she attempt to quiet him near Vanessa's crib because he's been drinking? Did a fight of some sort occur? That's up to you to decide what reasonable inferences that can be drawn from the evidence. But the story doesn't end there. It continues. No calls for help for Christine. No calls for help for the missing child. No parental concerns over the child. You would have to believe or why would you believe that home invaders who committed murder and kidnapped a child would leave behind a living witness? How does that make sense? Do you believe that they would also stop to take a child safety seat for the child at the scene of a homicide as they're making their getaway car from the car that Mr. Morales says is the real killer's? Does any of that make sense? And what does Mr. Morales do instead of calling the police or calling for help for Christine? He engages in a methodical cleanup over the next 37 hours before he finally leaves 6.5 Myrtle Avenue after Officer Kelly's welfare check at 1 p.m. Monday afternoon. And then he departs. He engages the deadbolt, cognitive processing. He explains he exchanged pleasantries with George O'Mara as he's going out. Not happy with the snow. Yeah, we still got time left, in the winter. He climbs into his car, he drives back to New Haven, where his other children are. No concerns about the naked, dead Christine in the bathtub and his missing child. This is the man that the defense would urge you to find not guilty. The court is going to instruct you with regard to something called consciousness of guilt. Judge Murphy will explain to you it is permissible for the state to show the conduct or statements made by a defendant after the time of an alleged offense that may have been influenced by the criminal act. The conduct or the statements show a guilty conscience. Each and every one of you who are parents, where you have said to your child, who did that, and got the story, therein saw the consciousness of guilt. I believe that you may infer from the evidence of the defendant's actions in cleaning up the scene of the crime, in disposing of evidence from the scene of the crime, in the flight from 6.5 Myrtle Avenue shortly after the welfare check by Officer Kelly on December 2nd of 2019, and his statements to the police about not being present at 6.5 Myrtle the entire weekend were all a direct result of his guilty conscience. Ladies and gentlemen, when you take your juror's oath, it does not require you to leave your life experiences and common sense at the courtroom door. Please do not do that. If you apply your life experiences and common sense to the credible evidence in this case that is available to you, it should satisfy you that the testimony of Jose Morales and the arguments of his lawyer are motivated by their self-interest in your verdict, coupled with denial and shame to Mr. Morales' family and to the greater Ansonia community that has been following this case for 5.5 years. Members of the jury, as I conclude my remarks, I would like to once again thank you on behalf of myself, the members of my office who have assisted me in presenting this case to you, and the people of the state of Connecticut. It is not lost on any of us the imposition this has been on your lives as you step up to make this important decision and to fulfill your role, your important role in civic function. I would simply ask you that as you begin your deliberation, remember, the credible evidence in this case indicates that the person who put the hole in the side of Christine Holloway's head is the very same person who within hours later is at that Shell gas station. I would respectfully request a verdict of guilty to the crime of murder and to the crime of tampering with physical evidence, and ask that you bring justice to Ms. Holloway and to her family. Thank you very much. Thank you, Your Honor.
Thank you, Attorney Stein.